A quick note for listeners. This conversation was recorded just hours before the Supreme Court of Canada's May 28, 2026 decision declining to hear an appeal in the Wolastoqey Nation case. That decision leaves in place an earlier ruling that Aboriginal title cannot be declared over privately owned land, and it's expected to inform legal arguments in cases like the Cowichan matter discussed in this episode. As a result, some of the discussion you're about to hear reflects the legal context at the time of recording. Welcome to The Critical Path, Greater Vancouver Realtors' professionalism and innovation-focused podcast. I'm your host, Jesse Lalime. Each episode, we sit down with industry leaders to discuss the critical issues affecting our profession and the paths we must take to overcome them. Now, if a client asked you this week, does the Cowichan case mean my title isn't valid anymore? What would you say? That question's coming up a lot for our members, and the honest answer is, this case isn't finished, and there's still a lot we don't know. Today, we're going to focus on what the courts actually decided, where the case is right now, and what remains unknown. Later on, we'll talk about how to approach those client questions responsibly while the case is still pending, and why we don't know yet can really be the most accurate answer. I'm joined today by Wally Braul and Josh Jantzi, legal counsel from DLA Piper here in Vancouver, to help walk us through this conversation. Welcome to you both. Thank you for joining us today.
Well, thanks for inviting us. We appreciate being here and to talk about, to the extent that we can, with any certainty as to what this case is all about.
There's so much going on, right?
Yeah.
And especially when it comes to the uncertainty, and that's really what we're here today, is to try and demystify some of this stuff. So we really appreciate
the word demystify is the right one. I think we're going to try to bring it down. We're not going to go do a deep dive into legal stuff. This decision is how many pages, Josh? 2,500 pages.
Well, 950, but that's still a lot.
2,500 paragraphs. It's a long.
Plus, yeah.
So we're going to spare our members the finer details in that, and we're just going to get to what they're going to need to know to talk to their clients about what's happening, because that's really what's happening out there, right? So before we get started, can you both let our listeners know who you typically act for in your counsel today, and how that helps your understanding of the counsel?
I'll start off. Josh and I have worked together for 20 years, or even more. And most of our clients, and especially in light of what they work with on these issues, are mining clients, oil and gas clients, and land development clients. And so there's a lot of similarities. A lot of the principles that were applied by the court are principles that were also quite evident in those other cases. We are litigators. We're not corporate commercial lawyers, but we are brought into a lot of transactions to provide advice from a Aboriginal litigation point of view. And so I won't talk about the particular cases, but they're not new principles to us. They have been being rehearsed and been applied different elsewhere. The only key difference, and we'll talk about this, is that the clash here between Aboriginal title and fee simple, which is a unique clash that is not found in such a blatant way as in other cases.
When you're dealing with big tracts of land involved with mining and forestry and things
like
that.
So Josh, some background, your background in Supreme Court of Canada, for example, would be helpful as well.
Yep, including on Aboriginal law cases. So this is a branch of our constitutional law that has its origins in King George III's Royal Proclamation of 1763, referring to Indian title, and that has been interpreted by the court since then as Aboriginal title. Our modern concept today derives from it. Then our Constitution got repatriated in 1982, and then Aboriginal title, as we conceive of it today, was elevated in that year to constitutional level protection. And that was front and center before the Supreme Court of British Columbia deciding the Cowichan case and the conflict between fee simple titles that were owned by Canada, by the city of Richmond, and by private landowners, and the conflict between those on the one hand and Aboriginal title of the Cowichan peoples on the other hand. And so happy to talk about all of that today.
Mm-hmm. Yeah, that's getting into a little bit more of the meat of it, right? There's, as we mentioned before, there's a lot of takes out there right now from people who think one thing or another without maybe really knowing. What's the single most important thing for our realtor listeners to understand about this case right now?
Well, I think sorry to say that's probably six, and we're not going to spend more than a sentence or two on each of the 6 points. When I say we, Josh will, and we'll cut him off at each point. But basically, there's 6 key points that that are prominent throughout the many thousands of pages in paragraphs. So, Josh, maybe just sort of take the audience through these just to remind them what those 6 points are.
Sure. So the first and foremost for your 15,000 members is that, strictly speaking, the Cowichan decision only resolved title issues. And like you said, it's not finished. There are still issues before the court to be decided, even outside of appeals. But strictly speaking, the Cowichan decision only itself relates to 1,900 acres, there, more or less, on Lulu Island, now in the city of Richmond. It does not decide any similar issues outside of those 1,900 acres. However, it is clear from the court's reasoning that its reasons are intended to be applied by the same court or other Canadian courts in respect of other land areas as well. There's nothing so extraordinarily special about the 1,900 acres that renders this court case specific to that, and that it won't ever have any application in the rest of the country. So,
looking to set a precedent.
Right.
Yeah.
So realtors do need to understand in the greater Vancouver area that the case will have some importance outside of Lulu Island. That is certainly the case. It's just the judge did not decide outcomes beyond those 1,900 acres. So that's the first point, in that the Cowichan people, the British Columbia Supreme Court has decided they do hold Aboriginal title over 1,900 acres, plus or minus, in terms of areas that they previously occupied, fishing villages and so on, dating back to the 1830s and actually prior to European
areas
contacts.
that are sometimes, or that are now submerged, which is a first, right?
Absolutely, a first in submerged lands, and we can certainly talk about that. I don't know how important that is to your 15,000 members.
Probably not going to be building houses on that part, so probably not a super important part of this discussion, but again,
but you never
part of
know
the equation moving forward, right?
What waterfront development may hold, and if we,
Exactly.
I grew up in North Delta, and so in South Delta, I'm well familiar. In Steveston, there are, some residential developments that are actually on water, and of course, submerged lands then become important for all of those dwellings. So it's not the case that part of the decision on submerged lands is irrelevant to real estate practice in British Columbia. It is relevant. It's just going to be like the least or most marginally relevant of everything the court decided. So back to your question, though, of what's the most important thing the court has decided here, is that Aboriginal title from the Cowichan peoples has been proven on the legal test. We don't need to go into 100 years of the legal test and its development over time. But to prove Aboriginal title, that test has been proven with evidence by the Cowichan people, and they hold Aboriginal title over those 1,900 acres. The second thing that the court decided that is very important to British Columbians generally, but also for the realtors, is that where Aboriginal title is proven, the court decided that the province did not have the authority to create fee simple land titles in respect of Aboriginal titled areas. Now, how do you know? The court has just pronounced Aboriginal title over those areas, but nonetheless, it is a conclusion the court arrived at. The province didn't have the authority to make the fee simple titles that it has made since the beginnings, the origins of the land title system in British Columbia. That is a hugely important decision that some observers, many legal observers, say is wrongly decided in law, and that is before the BC Court of Appeal in the appeals of this case.
This might be a good time to jump in and just get into a little bit about what fee simple actually is, right? Because that was something we wanted to break down a little bit. We hear a lot about title, Aboriginal title, Crown title, fee simple. It seems like they're kind of layered a bit, and maybe just kind of take us through kind of how those layers.
Let me maybe start off with that. The layering is it's a good way to put it. I think the layer started early on with fee simple. Mm-hmm. This is part of an integral, if not fundamentally important part of the common law that Canada has inherited from the Brits, okay? That is absolutely essential. It has been part of the British and now Canadian legal system for 800 plus years. It's a long, long time. it is unquestioned in other jurisdictions as one of the go-to principles underlying our countries, plural.
When it comes to owning property.
So now we have at the courts, and Josh mentioned the Royal Proclamation, King George, because of some battle there we were having with neighbors to the south, and an accommodation that was reached in 1763 with First Nations, then called Indians. So that is, no one anticipated that there was a need in 1763, for example, to resolve this 2026 clash of titles.
Right.
So that is now writ large as a result of the Cowichan decision. We can I'll maybe make a very brief comment. As everyone knows, there treaties were made as well, going back 100 to 200 years ago. And an important feature of those treaties, which are now constitutionally entrenched, is that the Crown can take up, quote unquote, using that phrase, lands that First Nations outside of reserves can use for trapping, hunting, fishing, and gathering. So that was already seen as some sort of an accommodation in anticipation of lands in those territories outside of reserves would be perhaps used for fee simple purposes, going back to the common law of real property. So I'm not suggesting that one can read too much into that, but I do know that we now have two very different competing legal perspectives. If on one hand being an 800-year tradition.
800 of a fee simple structure being you pay for a tract of land
title.
And you have an indivisible title to it versus a pre-existing Aboriginal claim that would have been there long before they had arrived.
And so fee simple titles were created by the Crown, either pursuant to legislation or before legislation, arising out of the assertion of British sovereignty over what was then British North America in 1763, and then its borders changed as time unfolded. Fee simple land titles come from the Crown's title, where they take up land, as that Wally just described, even contemplated by treaties, the Crown government's taking up land and reserving them for other purposes. Some of the lands have been reserved and set aside for Indigenous peoples. Those are literally called reserves. Mm-hmm. Other titles of land have been created by the provinces. So not just British Columbia, but all the Canadian provinces under their land title systems provincially, taking parts of those Crown lands owned within the landmass of each province and creating fee simple titles that can be owned by basically anyone. Sometimes governments, as we've seen in Cowichan, Canada owns some of the land parcels. City of Richmond owned some of the land parcels. But then also private landowners like you and me and businesses in the Lower Mainland own some of those land titles in the affected areas. And so when we're talking about fee simple land titles, it just means, yes, this is part of Canada's landmass. Yes, these are lands. And the ownership, whether it's private ownership or public ownership for those lands, has arisen pursuant to the laws of Canada and the provinces for making these tracts of land fee simple in the first place. And from 1867 onwards, when our Constitution was first pronounced by the British Imperial Parliament into law, there was a division of powers between Canada and the provinces. And it was quite clear right from the get-go there that provinces had the power over property and civil rights in the province to actually make laws respecting land and the creation of fee simple rights. And BC has had, since its entry into Confederation, its land titles system that continues to have effect today. So until the Cowichan decision, there was no real tension between private landowners or even public landowners owning fee simple on the one hand and Indigenous peoples on the other, because of the fact that it had been abundantly clear that provincial land title registration systems were properly authorized. What the BC Supreme Court has now decided differently in this case, and for the first time, and no other Canadian court has decided this the same way, but nor have they been called on to yet, is that in the case where Aboriginal title is also proven over a tract of land that could be fee simple, and is, in the case of the Cowichan case, fee simple, where Aboriginal title is proven, that does mean, according to the BC Supreme Court and its findings, that the province didn't have the authority to create the fee simple land titles in the first place whenever they were made. So over time, the province has taken up different tracts of land and made fee simple land titles and put them into the land title system. The province didn't have the authority constitutionally to do that. The trial judge decided that was a power of Canada only under the Division of Powers from 1867. So what does that mean? It means that the Crown grants of fee simple title, so for private landowners, but also the publicly owned parcels of land by Canada, the Vancouver Fraser Port Authority, and the City of Richmond. It does mean, in the case of those public authorities and governments, that the province didn't have the authority to grant those fee simple interests whenever they were made. And so whenever those have been conveyed and sold over time, by realtors for commercial and industrial real estate development, we'll get to the private landowners in both businesses and homeowners in a minute. But for the publicly owned lands by Richmond and Canada, with the exception of one land parcel that we can talk about, all of those land parcels were decided by BC Supreme Court to have been invalidly created, and they are an infringement, and what's more, an unjustified infringement of the Cowichan's title over those very same land parcels that the court has now, in August of last year, but still the case today, pronounced into law that the Cowichan have those titles. And so Canada's titles and Richmond's titles were declared invalid and effective. And what that means is, as of the current moment, and appeals are ongoing before the BC Court of Appeal, but currently, the only actual landowners of those titles that I've just described are the Cowichan people. Canada's land title in its various facilities that are on Lulu Island have been declared and adjudged invalid and defective. Same with Richmond's. So some of those are industrial and commercial developments on Lulu Island. And then, of course, we get to the thorny issue of what hasn't the court yet decided. And the court has not yet decided, okay, well, what about the privately owned fee simple lands? There are businesses, Montrose Properties is one of those. There are also home owners of residential dwellings in the 1,900-acre Aboriginal title claim area. What happens to their fee simple rights? Do they continue to hold them? Do they not? The court has not yet answered that question. What it has done instead, and the trial judge has authority to deal with the case procedurally as she saw fit, she has ordered. Now, in light of the pronouncements that she has made that we just discussed over these past few minutes, she has taken those factual and legal explanations, given them to the parties, and given an 18-month period post-August of last year for the various orders of government, Canada and British Columbia, to both go and consult with an attempt to reconcile with the Cowichan people the federal and provincial assertions of their interest in those titles with the Cowichan peoples over the remaining areas. So in relation to Canada, it's really simple and specific. Canada has one duty to consult here with the Cowichan people about the Vancouver International Airport fuel project lands. So I understand this is a petroleum handling area or an adjacent related series of storage and activities for aviation fuel and other things for Vancouver Airport. That land has not been declared defective, that land title, that fee simple land title for those areas. The trial judge did not. Unlike all the other federally owned lands in the area, she decided that one is not invalid and defective. So Canada currently owns it, but Aboriginal title has been declared over it by the judge. So what Canada must do during this 18-month period is reconcile the continued public and private use of that land, on the one hand, with the Cowichan people and their asserted title, which has now been proven for that very same area. The province, and this is the big one, the province has been ordered by the BC Supreme Court during these 18 months to go and reconcile with the Cowichan people its Aboriginal title as against all of the other fee simple landowners that have been granted by the province and that have been not yet decided. Are they valid, invalid fee simple titles? This is all of the business-owned lands and the homeowner-owned lands. What about those? And before the judge pronounces on that question and decides the rest of the case, she's directed the parties to try to resolve this themselves based on the current legal explanations that the trial judge has already given. So everyone must take that away as a government and try to reconcile those rights and interests with the Cowichan now. If they succeed, then there will be something akin to a modern treaty that resolves all the remaining issues of what about the private landowners. But if there's no treaty, no agreement that resolves this matter, then the parties come back before the court and the trial judge will decide the rest of the case. What about the conflict between Aboriginal title on one hand and the private landowners holding fee simple on the other?
In that event, which is probably more likely than not, that 18 months is, let's face it, is a very short period of time to grapple with these issues, let alone define the issues.
And we're within that period right now. Kind of.
We're 8 months.
About 8 months in.
Maybe longer,
Yeah,
but
since August.
we're well into it. Now, I think one of the inescapable issues here, with or without some happy conclusion here after 18 months, is this principle called unjustifiable or justifiable infringement. Josh alluded to that a moment ago. That this is a term that's not made up by us or by the court. This is a defined term that has worked its way through various Supreme Court of Canada decisions, and to address basically the essential issue as to whether there's a veto power of some sort, on the part of the First Nations, after having proven Aboriginal title. I think that's still very much a live issue, and that's going to be rehearsed many times, and I strongly suspect that people will see the unjustified infringement or justified infringement, whichever side of the fence you're on, as key to the resolution of this case after the 18 months, and many other cases after 18 months elsewhere. So, Josh, I think Josh and I have both been on cases where that is writ large, the arguments about what's justified, what's not. Mm-hmm. The key difference here, I think, is twofold. One is that there's such a graphic clash between what we called earlier, that this old principle, the nugget of the common law, real property law, and title, and Aboriginal title, that this is we're entirely in uncharted territory here on how is a court going to deem something justified or unjustified. That this is a very difficult case, and I wouldn't want to be a judge making that decision. It's a difficult one, but I can't.
And this judge tried to explain it.
Yeah.
I mean, it's something we haven't talked about here, but all of your members should know. It is undeniable that these lands, or at least a subset of them, were wrongfully taken from the Cowichan people.
This is an important
1840s.
asterisk on this aspect of this case. There was, in my view, out-and-out fraud by a certain civil servant who ran counter to the express directions of the Governor General, the representative of the Crown, back which year was that?
1843.
1843. So there was Mr. Moody took it upon himself to acquire those lands that were destined for something else, per Governor General the Douglas Governor Douglas perspectives.
So as
policies.
much as there's precedent going to be set
Yeah.
by this, there's also going to be a lot of case by case kind of basis.
There will be.
It's
inevitable.
Well, right?
Case by case on the basis of what is several things prominently. Is there enough? Have you met First Nation, the owners, to prove out title? For one thing. What about your competing neighbors, the other First Nations? Are you the only sovereign First Nation here, or are there competing interests? Another big step of evidence and procedure that has to happen here before things get sorted out and as to who actually has title.
Yeah. Because again, we were talking about the layers of the systems involved.
Yes.
It seems like that's similar to the solution that's going to come here, the layers of governments
Mhm.
and nations that need to come together,
Mhm.
right, to sort these things out. So
Right.
that seems like the status quo for right now. What's kind of coming next? Like where do you think we're going to see? Obviously, this 18-month deadline, this ticker is counting, but it seems like it's either going to be that pressure point or something before that you said was going to be akin to kind of like a modern treaty.
That's a good question. Excellent question. My best bet is that, the best efforts will be made to resolve something in the 18 months. And there's enough political investment here, one where, depending on who you're a politician for, that this is going to have to be resolved, or best efforts are going to have to be made, high priority efforts for the 18 months. Now, going beyond the 18 months, beyond this area, I personally think there will be a very big push by First Nations to advance their claims sooner than later. They can no longer afford to sit back and wait, because I think they might be facing arguments about not advancing their claims in a timely way, and they will be looking carefully at what their neighbors are advancing. In any case, there will be, hate to say it, more litigation. This will trigger more litigation.
I would say there's two other things that are next, if I may, as
I
well
was
as
just
those
going to
two.
ask, because we haven't really been itemizing the 6 points.
Yeah.
I think we're covering them more or less.
I want to make sure that we're staying
Yeah.
true to that and getting through. So if there's other parts that we need to get to here, Josh, please.
So there are.
Yeah.
So there's two other things that are undeniably next. The first is that every single party that was involved in the Cowichan litigation before the BC Supreme Court, they've all appealed. Even the Cowichan, which I'll get to in a minute. But
Interesting.
Canada has appealed. British Columbia has appealed. The Musqueam and Tsawwassen nations have appealed. The Cowichan have appealed. So everyone except for the Cowichan there is going to argue that the court was wrong in making the main pronouncements that we've discussed in here today about whether the province had the authority to make the land titles that it did, and whether or not the fee simple creation of lands was an unjustified infringement of Aboriginal title. The Cowichan have a different appeal. Their appeal is that their claim was much broader than the 1,900 acres that the trial judge ultimately declared to be Cowichan title. It was much broader than that. They certainly have an assertion of title over a much greater part of the province than just these 1,900 acres in Lulu Island. So their appeal is about whether the trial judge got it wrong in incorrectly dismissing parts of their land claim as having been insufficiently proven with evidence. So that's one part of what's next, is that appeals will be proceeding. That will be to the highest court in the province. That's the Court of Appeal for British Columbia. Those appeals are ongoing. There's 7 sets of appeals. Those are going to be consolidated and probably heard by the Court of Appeal together. They may or may not be expedited, given how important this case is to trading commerce in the province, certainly for your 15,000 members. As realtors administering conveyance of land in the province, not just Lower Mainland, but elsewhere as well, because so much of the province, we haven't talked about this, is unceded land, to which there are no modern treaties. There are some, but much of the land mass of British Columbia is completely unceded, unsurrendered land to the Crown, over which extant Aboriginal title claims have been brought. So that's one thing, is the appeals will proceed. The other main thing of what's next is, before the trial court itself and after the court's judgment so far, private landowners have come out of the woodwork, for lack of a better term, like Montrose Properties, that owns fee simple lands in the area. And again, recall that the validity of their land titles has not yet been pronounced upon by the trial judge. But they would like to have a voice in whether their title is valid or not.
Of course.
And they're not a party in the litigation because they were never made a defendant by the Cowichan plaintiffs. And the Government of Canada did, early on in 2017, bring an application before something called a case management judge dealing with the procedural issues before trial, the Government of Canada did apply for an order obligating the Cowichan plaintiffs to serve all potentially affected landowners, including Montrose Property and all the other private landowners, with notice that the case is ongoing before the court and that if they want to participate, they better do something fast to get joined as a party in the litigation. That did not happen. The case management judge at that time decided that the Cowichan did not have to give that notice. Now, can and should Canada and the government of British Columbia given that notice anyway to all potentially affected landowners? They could have. I imagine for a variety of reasons that don't make public, those governments have decided not to bring in all the private landowners. Now there's a problem. Those private landowners' rights and the validity of their titles are at risk of being pronounced upon by the court. Maybe they would find them valid. We don't know. We don't know what the court's going to do. But the point is, the court is going to decide what about the conflict and validity of their titles that they own as private landowners when faced with an existing declaration of Aboriginal title over their specific lands, the same land titles. What about that conflict? And they're not even in the court. So what has happened in this, and it's definitely part of the next steps, the Montrose Properties has actually brought an application to the BC Supreme Court to reopen the trial and be joined as a party defendant and be able to submit evidence and argument to the trial judge about the validity of their title before the judge decides the validity of their title. Some observers would, from a common sense perspective, say, well, of course they should have a voice in the outcome of their own property rights. How could they not? Well, this court has already decided that they were not entitled to this before the court's judgment. Why are they entitled to it post-judgment? And the Cowichan plaintiffs, the Cowichan tribe, has opposed that relief in the court, saying you shouldn't reopen this case, Judge. The fee simple landowners, including private landowners, they knew because this was the subject of public commentary, and they knew from regulatory proceedings with the province of British Columbia in relation to the industrial land park and so on. They must have known from the province that all of this, the validity of their land title rights could be adversely impacted by this case. So you shouldn't reopen the trial now and put us through the injustice of having to re-argue the case again when this has already been the longest trial in Canadian history, some 513 trial days. I may be wrong about the exact number, but it's arguably in terms of court time, the longest running trial in Canadian history.
Precedent setting in another way.
Right.
Just by its scope and size, hey?
But I do think it's important, and there's been a lot of commentary in social media and in the Vancouver Sun and other mainstream media that we should clarify the facts. So the facts are that in relation to these private landowners now asking to be heard by the court before the court decides the validity of their fee simple titles, Canada has supported that. The government of Canada, and this is even the subject of questions and answers in question period in the House of Commons in the last 3 days. The government of Canada has said publicly, it's in the House of Commons, they will protect the rights of private landowners, and they are supporting the Montrose Properties application to reopen the case so that their points and views will be heard by the court before it pronounces judgment. Now, you can criticize that until the cows come home. That, well, that's great, but you're leaving it to a private sector, a private landowner, to have to advance and advocate for the private property rights of all of the affected landowners in the claim area and arguably for the rest of the country. Why isn't the government of Canada doing that? And Canada has been criticized, and Premier Eby's government and predecessor government have been roundly criticized for not advancing something called the extinguishment of Aboriginal title. That we understand title may be declared, but by the creation of fee simple titles that are privately owned, whether it's at the start of the entry of BC into Confederation or in years since then, private landowners have acquired titles in what is now Lulu Island. I mean, it's not a small island. This is the core of Richmond, not the city center, but on the map. This is Richmond, north and south of Highway 91, going westbound into the city of Richmond proper. Why didn't Canada and British Columbia argue that the creation of those fee simple titles for private landowners was not necessarily paramount and supreme over Aboriginal title, but that it extinguished the Aboriginal title that might otherwise lie in those land titles, those parcels of land? Why didn't the governments argue that, especially where there were no private landowners before the court for their views to be heard? I, again, do think that those governments can be justifiably criticized by the public for not having brought those issues to bear before the court. Canada will say, well, we tried. We applied to the court, obligating it to bring this litigation to the attention of private landowners, and that didn't happen. But that, of course, doesn't answer, well, why didn't you tell the landowners anyway, Canada?
Yeah.
And the term extinguishment is also a coined, defined term by the courts. This is not something that has come up. It's sort of in a common parlance or in other ways. It is the courts have been, especially the Supreme Court of Canada, has been fairly careful to define a template how this is all going to be resolved. And within that template, there's a concept called extinguishment. So that's going to be, I'm not going to suggest how that's going to roll out here in this case, but I do know that that's going to be likely picked up and used by some of the appellants.
It's a heavy term, extinguishment.
Yes, it sounds like it's
almost dismissive.
Nuclear option.
Yeah.
But it's
politically unappealing.
The court did say that, look, there's a range of opportunities here to somehow deal with this. They've attempted to. It's a difficult series of questions. Yeah. And one of them, they, to their credit, the court's credit, they did utter that there is an option called extinguishment, just to complete the picture. So,
I wonder, getting back to the timeline, that 18-month kind of period. You've got all these appeals kind of lining up on the other side. Like, how does the timeline? It seems to me some of these appeals could potentially take longer than the 18 months to resolve.
Much longer.
So, how does that timeline? How does that kind of intersection complicate things?
So, I mean, one line of reasoning, and we don't know what the Court of Appeal is going to do in administering its process before it hears all of these extant appeals. We can't say for sure whether the Court of Appeal is going to delay in any way the hearing of these appeals because the trial court has not yet done its work, at least not to completion. However, a significant part of the trial court's work is done after the longest case in history, and we do have a judgment, and it is 950-odd pages, spanning some 3,700 plus paragraphs. So there is very much that has already been decided. Therefore, one line of observers will say, well, the Court of Appeal should go ahead and hear all of these appeals and not wait for whether the trial court does anything further. However, there is a complication in the trial court that now comes from private landowners coming before the court saying, reopen your trial, I haven't been heard yet. How can you decide the validity of my title without hearing from me about it? And will that persuade in any way, shape, or form, whether formally or otherwise, the Court of Appeal and how quickly they hear their appeals? One thing is abundantly clear, and it is undeniable and not my opinion. I see it in practice. This case has changed trade and commerce. I don't do residential real estate development, but this case has definitely changed in meaningful ways lending risk and due diligence on land deals and development deals. That is undeniably the case, meaning this is all a subject of pressing and substantial importance. I don't know that this is somehow a decision that is a dominant explanation for why condo sales in downtown Vancouver have decreased over the last 12 months. But regardless, it is undeniably a pressing issue that bears upon trade and commerce. And so much of the gross domestic product in British Columbia has come in a significant way from the conveyancing of land titles. In many years, obviously, this is a destination that everyone around the world finds appealing. And so, the purchase and sale of lands has been something that has driven provincial coffers on a tax basis for quite some time. This is important, therefore, for the British Columbia courts to resolve. And Jesse, to your point, not going to end here. Very likely to go to the Supreme Court of Canada. So how can it come soonest before the Supreme Court of Canada? There's really two paths. The path that we're currently on, where the BC Court of Appeal is going to decide the appeals before it first. And then if people are unhappy with that, they can ask. They don't have a right, per se, to be heard by the Supreme Court of Canada, but they can ask for the Supreme Court to take up these cases and hear and decide them. Or the Attorney General of Canada in Ottawa does have the authority to take these constitutional questions, at least the legal dimensions of them, if not the factual ones, and put them to the Supreme Court of Canada and get a quicker answer from the Supreme Court of Canada on such pressing and important things as, did British Columbia have the authority to create fee simple titles over parcels of land that are subject to Aboriginal title? Because the British Columbia trial court has said that it did not. And that is a huge area of uncertainty for the rest of the province, certainly the unceded lands that are capable of supporting an Aboriginal title finding. But it is important for the rest of Canadians to understand not all of Canada's landmass has been the subject of historic or modern treaties. There are 9 million acres of Eastern Ontario that are claimed by the Algonquin peoples of Ontario. That's 36,000 square kilometers of Eastern Ontario, including the entire National Capital Region, that is the subject of an extant title claim. Is that case going to go to court? The parties have an agreement in principle how they're going to try to resolve this. And so this is not meant to be fear-mongering in any way. But the Tunaha people of British Columbia assert the title and traditional territory over southeastern British Columbia, but also parts of southern Alberta, including the city of Calgary. So it is no answer for Albertans to take the view, we have no risk here, we have treaties 6, 7, and 8. Not quite correct. It may be less risk than completely unceded lands, like in much of the landmass of BC, but vast parts of Quebec, New Brunswick, Nova Scotia, Newfoundland are not the subject of historic or modern treaties. There are historic treaties for Nova Scotia, for example, called the Peace and Friendship Treaties. Those don't involve the surrender of land at all. So all of these other parts of Canada will be looking with much interest to this BC Supreme Court decision, the appeals that come out of it. In fact, there is a different case that has been related on Aboriginal title in New Brunswick. It's over 200,000 plus titles of provincial lands, fee simple, I believe, that has gone before the New Brunswick courts, and their Court of Appeal has decided something different than British Columbia's. Their Court of Appeal has decided before Aboriginal title can even be proven or pronounced over those land titles at all, the private landowners have a right to participate in the litigation. So that does not mean that the New Brunswick court would decide that Aboriginal title isn't found or the test isn't met in their province. It doesn't mean that, but it does mean procedurally, private landowners, including J.V. Irving for their industrial sites that were part of the claim area in New Brunswick for oil upgrading and export facilities, all of those landowners have an opportunity to be heard in the litigation and will be heard before the New Brunswick courts decide on those title issues in New Brunswick. Now, is there anything in the law that says British Columbia's procedural laws can't be different? No, they could be different, but we'll see whether the Court of Appeal decides whether or not certain fundamental things like fairness and natural justice afford private landowners an opportunity to be heard before their titles are declared valid or invalid by the BC court.
There was a nuance that I wanted to get into because you were talking a bit before about your experience in the land deals that you've seen and how things have been affected materially by what's been going on. I wanted to zoom out a little bit and take a bigger picture look about how this case kind of intersects Aboriginal title and other land title systems with development in BC, because we're seeing one of the biggest land developers now in BC are Indigenous groups. So, it's a little bit more of a kind of a nuanced question, I think, but like, how is that kind of all intersect? And you got into a little bit about it with, what you're seeing risk mitigation and stuff like that. So
Yep.
Is there more to that?
There's more to that. Certainly, there's certain things that are undeniable that in our current state of affairs, factually and legally. The reconciliation, and I'm talking like Truth and Reconciliation Commission calls to action, but all of the government actions thereafter that are taken to support reconciliation activities have led to exactly what you've just described, with many development projects actually being Indigenous-led or Indigenous-owned, or at least majority Indigenous-owned, whether it's 51% or 100% of a proposed development in a joint venture in whatever way, shapes, or forms that would be, to build wealth for future generations of Indigenous people, and also to assist in trade and commerce and to build profit for landowners generally that are non-Indigenous. We see these joint ventures, or in fact even just Indigenous-led and owned developments. Does this case affect those? In a certain sense, no, and that would be as follows. For lands that are already determined to be Indigenous-owned fee simple lands, or even other Indigenous treaty lands, and I'm thinking modern treaties in the case of the Tsawwassen First Nation, where I'm from, but also this would equally apply to the Niska and other recipients of modern land claims agreements, where they have, as a part of their treaty, as Indigenous peoples, control over the development and use of their own lands, including the ability to make laws in respect to the developments of those lands. They can do so and are arguably unaffected by court cases like this that pronounce upon Aboriginal title, for the mere reason that there are no disputes, that many of these lands are Indigenous treaty lands. Now, that's not a complete answer. The rest of the answer is where Indigenous-owned development projects are on non-treaty lands and lands that aren't yet the subject of Aboriginal title. Take, for example, lands in the Greater Vancouver area, but the city of Vancouver has not yet been the subject of any modern treaties in these respects. So what about those developments? They actually do have, despite being Indigenous-owned and Indigenous-led developments, they do have the same title risks that non-Indigenous developers have, which is, we have seen, and again, there's been much fear-mongering in social media that the government of Canada has given away the entire city of Vancouver and Musqueam claim area to the Musqueam people. That is not factually correct. That is wrong. But what Canada has done is it has acknowledged in 3 implementation agreements that fall short of being a modern land claims treaty with the Musqueam. They have acknowledged that there is Musqueam title over the claim area. But which parts? And the agreements don't say which parts, and the government of Canada hasn't said which parts. And what all this means is that going forward, Canada is going to make clear at some point, whether it goes before the courts or it's in a modern treaty, Canada is going to make clear which parts of the Musqueam Territories claim area the Musqueam do have title over. And their claim area is vast and extends up to, Whistler, Lillooet, and down south towards the U.S. border. So it's a huge claim area. So what does this mean for Indigenous-owned developers for major projects in the Lower Mainland that are not the subject of a treaty? It means they run the risk that because we don't yet know whether Aboriginal title of, doesn't need to be the Musqueam, but if the Musqueam, for example, have a project development, or the Squamish have a project development company that is advancing major land redevelopment, they do run a risk, whether it's a small risk or a large risk, we don't know factually, that another First Nation will be bringing its Aboriginal title claims before the British Columbia courts, possibly after the development is complete, and that a fee simple title is actually undermined or imperiled by the declaration in future of an Aboriginal title over their chosen development area. That could happen, and there's no way around that other than the appeals are proceeding and private landowner rights are going to be soon decided. Are they going to be before the BC Supreme Court in deciding the rest of the case, or do they have no right to be heard in relation to the validity of their land titles.
It's almost another like hurry up and wait scenario,
I
kind
think
of, right, in terms of some real answers.
The Chilcotin Agreement, where there's a big landmass. What happened there is that Chilcotin made, or Chilcotin, however you pronounce it, made a deal with the neighboring First Nations. And I think that those sorts of negotiations will play out as well. These are for the non-treaty land areas, so that the overlap question goes away. So will that happen? There's a lot of money on the table here, perhaps arguably more than what's up in Chilcotin. So whether that sort of negotiation will occur, and even if there is not that competing overlap issue, there will also be a lot of negotiation between, say, the Crown and that First Nation outside of the treaty to say, basically, the Crown might say, well, we're prepared to talk about non-treaty areas with you for economic business development and so forth, and land development, but you've got to give us something that you'll make peace with the other areas around us. So that's another form of negotiations that will take place as well. One can imagine that there'll be several fora of negotiations in the future, driven in part by the recent decision.
And so, again, with almost the kind of the hurry up and wait nature of some of this, is it just a matter of getting some of those answers kind of in place before moving forward, or is there more we can do? Is there more that can be done?
I think what it tells me, I think it's a good way to put it, hurry up and wait, that 18-month, no one should expect much. I hope I'm wrong in the 18-month period. Moreover, I don't think a judge might be impatient to extend the 18-month period. And parties might be impatient. They want to get this sorted out. They don't want this to be filibustered for any extended period of time. So one should not be optimistic about a court saying, oh, yeah, if progress is being made, let's go for another 18 months.
Yeah, the uncertainty is what drives so much of the misinformation. It's what drives so much of the fear, and the longer that lingers, I think it doesn't do anything for anyone. Further 18 months,
for example, would just create would have a huge monetary implication.
Mm-hmm.
But before people form their judgments or prejudgments about how title risk is, in one sense or another, inappropriate fear mongering that is intended to undermine the interests of Indigenous peoples and so on. I think everyone, we can all agree, we can disagree about the consequences of facts, but we should all be operating from the same facts that are undeniable. Like, for example, the Member of Parliament for Skeena-Bulkley Valley, I think it's 2 days ago, possibly 3. He is name is Ellis Ross, and he is a former chief of the Haisla Nation. He is an Indigenous person, and he has raised these questions in the House of Commons and has himself put his own views to the federal government, saying this is not fear-mongering, that there is uncertainty for private landowners in the face of this BC court decision, and we need to look no further than the fact that the main defendant that is appealing is Canada. And so if that is the case, at least from Indigenous peoples who are members of Parliament, making clear that this is not fear-mongering. Everyone does need to have some certainty going forward where we continue to operate as an effective society with trade and commerce. That is a pressing and substantial public objective that affects Indigenous and non-Indigenous peoples alike. So we must achieve certainty. But to your question, Jesse, about do we sit and wait or wait and see in what happens going forward? What we have seen in land development practice, both for resource and energy projects, but also for land development generally for commercial and industrial, and I haven't seen it for residential, but I'm sure it's going to come up, is there's due diligence to be done on these deals. And of course, your member realtors play an important part of that due diligence. Yes, lawyers do as well, but frontline is, of course, realtors for purchasers and vendors. And so what is going to ultimately happen, and is happening, is previously a title review looked at the BC land titles registration system, registration of instruments on title. What are they all? Are there any that are known that are not registered in interest? It doesn't mean that those interests in land don't exist and have legal force. It just means they're not registered in the land title system. And of course, if we miss these, then we miss out on potential title risk. That is exactly what this Cowichan case is, though, is an aspect of title risk that none of us are going to find registered on BC land titles, at least not at this current time. So how do you then complete your due diligence on deals and so on? You almost have to look into, well, is there an extant Aboriginal title claim that has been brought in this area? Some of that is publicly accessible information. The BC Treaty process, the BC government website, the federal government website are all certainly going to be areas of some information for this. But some of this is inaccessible. Treaty making is a confidential process between the Crown and a given Indigenous people that non-Indigenous people like me do not have a right to access that information if it isn't already public. So I won't be able to know what is happening. In my practice, though, I have learned of these asserted titles and land claims in some instances where they're not public. They are public now. For example, Southern Ontario is not immune to these types of issues, despite having been largely treated over time. There are some parts of southwestern Ontario that I learned in pipeline proceedings before Canada's National Energy Board at that time, now the Canada Energy Regulator. I learned of many different asserted rights and interests that are not publicly available on the Ontario government's website. There are submerged land claims made by Ontario First Nations that are conceptually similar to what has been argued in British Columbia. And then, of course, some of Ontario's treaties do not effectively use the word submerged lands to make it clear that they are surrendered. And other treaties in southern and southwestern Ontario do not use the word surrender. So they are possibly unceded tracts of land. So this is definitely a question of national importance for Canada as a whole. I do think that's why Canada is such an active defendant and now appellant in the BC Court of Appeal, because these issues are not British Columbia specific. They're important to BC because so much of the province is unceded, but there are unceded parts of the whole country that need a path forward. So what can and must we do? I don't think we're going to see development grind to a halt, but there's something we haven't talked about very much that does affect arising out of this case, land development, and that is the lending. And there are matters that are confidential matters of law firms and so on that you won't be able to hear about. But there are also public statements, or at least the subject of written commentary, that lending practices have or will change to some degree as a result of this case, if for no other reason, and there are other reasons, but if for no other reason, then land value may be affected by an increased Aboriginal title risk that before this case came down in August of last year, the court's decision, Aboriginal title risk, it was a risk, but it was not quantified in any way. And many different members of, industry, developers, buyers, sellers, may have just simply been of a view that this is something that isn't front and center as a part of our overall deal risk. So it is not something that we can quantify or deal with, and it doesn't affect land value.
Now it's moved to a game changer.
I think so. Yeah. Certainly for these 1,900-acre parcels. But even outside of them, there are other land title claims in BC that are unresolved. The BC treaty-making process has been ongoing for many years. It has not succeeded in reaching treaties with all potentially affected BC First Nations and Indigenous peoples. So where does that leave us? Certainly governments, I think, are going to try to arrive at agreements with First Nations to resolve these issues of land claims and thereby decrease overall title risk by giving some finality and certainty to it. And I don't want to fearmonger, but everyone should have in mind, again, I'm thinking peoples in Alberta, Saskatchewan, and further east. And I do practice in Alberta and Ontario as well. They are not insulated from these risks because even in the case of actual surrendered treaty land, there is a risk, and there are proceedings before the Alberta courts in the last 20 years, where even in the case of a treaty, there is an argument that has been made by some First Nations that the treaty is not legally operative in all respects, that the treaty was an improvident bargain. Northwestern Ontario, Treaty 9 territory, there is at least one Ontario First Nation in Treaty 9 territory that has asserted that the treaty is ineffective, they did not know what they were signing, and that their title rights are not fully and finally resolved simply by the wording of a treaty. Now, the more modern the treaty gets, probably the less risk overall there is, because it would be difficult to say, certainly in modern times, that with the benefit of legal advice, and Indigenous peoples have in many respects great legal advice, and we have acted as a law firm for Indigenous peoples as well, including some proponents for resource activities. And we've also acted for regulators and simply non-Indigenous industry. But the point is, for modern land claims agreements, yes, those are going to be the areas of least risk that arises out of this, with the treaty not being fully and finally resolving a matter.
That's great, because you really can come at that kind of answer from both sides, having the work experience that you have on all of that. So
usually we don't act in the same file.
Yeah, right, right. But I mean, it really lends to the kind of the information that we're sharing here. So I really appreciate you digging into that a little bit. I want to bring it back to our listeners, because the clients they serve, some own property in the areas that are affected. Some aren't sure if they're affected. We've talked about the implications that could come further. Given all the facts that we have in terms of where we're at right now with the case, the appeal period, or the 18-month period, it's a lot for our members to kind of distill into an answer for when a client comes at them with a question like that. What is the best way for our listeners to handle these kind of questions when they come up with their clients? What can they really responsibly say about what's happening right now, and what kind of advice can they give?
Well, I have thoughts, but
obviously not legal advice,
yes.
right?
I mean, I think one
practical
practical piece of advice is be very site specific. Understand what it is, which area. Do your homework to the extent that you can.
Yeah, because that was another factor, right? We were talking about it can be difficult to find some of these things, if not impossible.
But it's still a risk situation. It's not a wholly uncertain situation. There's a difference between risk and uncertainty. So you can actually start to weigh some risk to say, okay, in this area outside of Kamloops, for example, well, let's talk about what sort of risk there might be here. What is it that the First Nations have said publicly in terms of how far they're advancing their claims, and what the timing might look like? In some instances, the treaty negotiations are far advanced. They're getting close to a finish line, and I think this case will expedite or kickstart some dormant negotiations. But so that would be one absolutely critical starting point, is for realtors and their clients to understand precisely, without getting into too much sort of rhetoric about this whole area, because people have very strong views on one side, every side on this, is dial down into the facts of what it is. And there will always be more than one nation, almost on every site across Canada and BC. So understand what other nations are saying about this lands, not just the nation which appears at first instance to be the most important and relevant one. And I know I'm not giving a lot of thought, again, prudent advice here.
It's tough to boil down into one.
But I would start
one
there.
Thing, right?
Start there. Do the homework.
Yep.
A local homework.
Local homework.
And
hey,
then,
Josh, what about you?
As for what your members can say when they're faced with these questions, and this is not a plug for legal work or anything of kind, it depends on the question asked. I can think of lots of questions that your members are getting asked,
For sure.
including some owners may be sophisticated enough to even ask the question, I understand that the court has found that where Aboriginal title is proven, and it's not proven over my lands right now, well, unless they're in the 1,900 acres.
In that spot.
But, adjacent, Burnaby, Vancouver, New Westminster, Delta, White Rock, South Surrey, any of these areas, and of course the whole rest of the province that's not ceded, your members may be asked, okay, well, if Aboriginal title is declared in future over by a court or a treaty over the land that I own, does that mean that I don't own it anymore? And the answer to that should be, that is, despite all of the rhetoric that is out there in commentary in mainstream and social media, an undecided question at this time. For private landowners, we know what's happened to all of the publicly owned fee simple lands, Richmond and Canada. Those lands have effectively been transferred to the Cowichan tribe. But it does not mean that that is what is going to ensue for everyone else that owns land in this province privately. So, the answer back to them will be, at least at this moment, and the answer may change after the matter comes back before the court or a treaty is made. But as of this moment, that question is totally undecided. And there is at this time no existing risk that any private landowner in the province is going to be dispossessed of the land that they currently possess and occupy and own exclusively. Is there a risk in future that relates to the validity of that land title? Yes, while this matter of private land ownership rights and the conflict between it and Aboriginal title is unresolved, there is a residual risk that where two things have to happen. First, somebody, like a judge or a treaty government, is going to have to pronounce in law that Aboriginal title exists over a tract of land that one of your members' clients owns. If that doesn't ever happen, then they have no risk whatsoever along these lines. And two, if that ever does happen, is there also a determination legally by a judge or a treaty maker that the infringement of the Aboriginal title is unjustified? If so, then yes, in those circumstances, which are hypothetical for almost all the private landowners we're talking about right now, then yes, in those circumstances, there is a risk that their title will be at peril. But, and there is a but that your members can also say to people asking that very question, there are appeals ongoing to the BC Court of Appeal and in all likelihood the Supreme Court of Canada, including by very important litigants, the government of British Columbia, the government of Canada. I'm not saying they're more important than the other litigants, but the fact that they represent the entirety of the people of British Columbia and the entirety of the nation tends to suggest that their decisions of what to do and not to do in litigation is important, and they have chosen to appeal. The Attorney General of BC, when the appeal was taken, did publicly state, among other things, that she intends to argue the case before the courts in a manner whereby private property ownership is protected. In the House of Commons in the last 3 days, various members of the federal government, the Minister of Crown Indigenous Relations and others, including the Prime Minister, have said that they intend to protect private land rights. Now, they're not the judge. They're just litigants. So their opinions don't necessarily matter or decide the issue. But the fact that they are appealing from this decision and that they have publicly said in question period in the House of Commons as the Government of Canada that they think that the BC trial court has incorrectly decided the case, including Canada's Attorney General has said as much in answers in the last 3 days, tends to suggest that what realtors can say to in response to questions along these lines are that next steps have not yet occurred. So firstly, any risk to your private land titles, private landowners, is contingent on events happening in the future, an Aboriginal title being found over your parcel of land. What are the odds of that? The BC landmass is huge. The test for Aboriginal title, which we didn't get into in this discussion, nor could we in the time we have, has arguably changed over the years. It used to be a much heavier lift than it is now. So does that mean it's easy to prove Aboriginal title? No. Does it mean that it is capable of proof in many more circumstances than it was previously in the 1990s and in the Cowichan case that Wally described in 2014? Yes, it is a lighter lift now to prove Aboriginal title. So one, that's a contingent future event. If it does happen, the other message for your members' clients asking them would be that the appeals haven't been fully and finally decided. Yes, this is a judge of the province of British Columbia Supreme Court. Her explanation of the law and her decision so far actually is the current law in force in the province. Her decision has not been reversed on appeal, but all of those things may happen in future. So I think that must be said to somebody who raises just the biggest concern of, hey, am I going to lose my land title? I paid off my mortgage. The land's not mine.
Right.
It cannot be said right now that the land is not theirs. Not unless and until this case progresses, the appeals progress, something changes.
Yeah.
People have asked also, and they might ask realtors, well, aren't governments going to simply change the laws? Well, that's a thornier issue that we, again, haven't been able to talk about with our time today. The Aboriginal title we're talking about has, since 1982, had constitutional legal force. It arguably, to the extent of any inconsistency between it and a non-constitutional property right, like mine as a non-Indigenous person in a fee simple and a title to land, to the extent that it's inconsistent with Aboriginal title, and we don't yet know that from the court, but if it is inconsistent with Aboriginal title, the Constitution reigns supreme, which means that the constitutional Aboriginal right would prevail over a private landowner's right. So it's not simply a case of there being political will in the government of Canada or the government of British Columbia to pass a law that says, regardless of what this judge said, the following is the law of the land. That is not.
It just doesn't work that way.
No, but it doesn't mean that there is no part for lawmakers to perform. And so they shouldn't escape scrutiny in the House of Commons and otherwise. If we do later have a complete constitutional crisis on our hands, whereby parties are being dispossessed of land titles all over the place in respect of unceded lands in the country, the provinces and the Parliament combined, with consultation with Indigenous peoples, can change the Constitution. And the Constitution does not say that the Indigenous peoples have a veto over changes in the Constitution. So if we get into some dire circumstances where our trading, commerce, and property conveyancing is falling apart nationwide or province-wide, if we ever get into those dire circumstances, which I hope we do not ever do, there are constitutional amendments that are even contemplated in our own constitutional law that could happen if absolutely necessary. But Wally and I could, in other contexts, getting into the finer points of law in these cases, paint a picture for how there's a path forward that doesn't even require such things. And one of them, I don't know if there is any time, but is on the discussion of and the findings of courts in Canada on whether or not an infringement of an Aboriginal right is justified, having regard to all the circumstances. If an infringement of an Aboriginal title is found to be justified in all the circumstances, then the consent of the Aboriginal title holder, the Indigenous people in question, is not legally required for those infringing activities to continue. It doesn't mean that nothing happens. They're entitled to compensation for infringements. Infringements, whether they're justified or not, require compensation. And it could be significant compensation for the loss of Aboriginal title rights. But if it is a justified infringement, the current state of our law is clear that consent is not absolutely required from the Indigenous rights holder, in this case a title holder, for the infringing activities, the grant of fee simple land rights to continue in time. Where it's an unjustified infringement of Aboriginal title, and yet we still haven't seen the trial court pronounce upon this, but based on very established principles that Wally was talking about over the last 20 years and beyond. An unjustified infringement of an Aboriginal right or title, arguably, requires consent for the infringing activities to continue. The Cowichan case was a very good example of that. It's not urban developed lands; it's Crown rural lands more towards the interior of the province. But in that case, for forestry, timber harvesting, the Supreme Court of Canada dismissed British Columbia's assertions of a justification for infringing on the Aboriginal title to allow timber harvesting to occur for a whole ton of reasons that we don't have time to get into: Asian pine beetle infestations, decrease in the commodity value of the timber, etc. All of what the interior development of the economy in the interior of British Columbia, all of those were asserted by the provincial government as justifications to allow the infringement, which would be harvesting timber on Crown land, to occur. The Supreme Court held the justification was not proven in that case.
Aside from those few examples, we don't have a long list of what's unjustified, what's justified.
Right. That's where it gets really gray.
That's where it gets gray. And I do think that grayness will go away. I think because the concept of justifiable versus unjustifiable infringement is going to be so fundamental to a lot of the resolution of these cases that we'll get that list eventually. But that gives your little solace to your clients, to the realtors out there. Yeah. But that's inevitable.
Well, at the end of the day, these are complex questions, right? Yeah. And they have complex answers. And I mean, I feel like there's plenty in here that our listeners will be able to take away, that they can at the very least have an informed conversation with their clients about what's happening, and not necessarily, a cut and print answer, right? Because so much of this is still up in the air. So much of this is we don't have answers yet, and that's okay, because that's where we're at in the process right now.
It is. And even the Cowichan peoples, and I'm trying to present the most, balanced views that I can here, they have publicly stated, even as litigants in this litigation process in which they have prevailed to obtain a title declaration over 1,900 acres, they have said that they have not asked to evict or dispossess anyone of their land titles, even though, ironically, they were dispossessed of their annual fishing village on Lulu Island those many years ago. So they've not asked that. However, that is not a complete answer for all of your listeners, because we are dealing with what rights do they have, and could they, if they don't come to resolution with the provincial and federal governments and others, with a negotiated settlement of this whole dispute, could they come to court and say, well, we don't consent to the continued...
There could be a regime change within the First Nation. So barring any long-lasting, very firm and clearly stated agreement, that's always a risk, that lingering risk outside, and I've read the same comments by the Council for the First Nation and the leaders, that the word, we don't intend to evict, basically. But is that...
There's a measure to cool things down a bit, almost, right?
And then to their credit, that was offered. But I do think that it all calls out for more agreements to confirm what those longer term intentions are.
A lot of talking, a lot of stuff still to be resolved. So
right.
Here's the problem with agreements. Just one final word on this, though, is that is exactly what was attempted with the Cowichan. And again, the responsible minister in question period in Ottawa, just the other day, did describe it this way, that negotiations with the Cowichan failed, for which reason they litigated their rights in the courts and obtained a decision from the court that the government of Canada thinks was wrongly decided. And so they are appealing. And there are lots of different defenses to the Aboriginal Title Declaration that all of these defendants, including Canada, BC, and others, asserted, including common law property defenses that many of your realtor members would certainly understand when it comes to different people claiming rights over the same land parcel. Like, well, what about the current owner? There's the concept of bona fide purchaser for value without a competing notice of a competing title claim, that if they bought the land free and clear, even if there was some historic other entitlement of somebody else in that land parcel, isn't the current owner going to survive with their land title intact? All of those arguments were asserted before the BC Supreme Court, and they were unsuccessful in this case. What about limitation periods? Deadlines to bring litigation? Surely the Cowichan people knew for the better part of 155 years that they were wrongly dispossessed of these land titles. The Superior Court in the province has decided that is not a barrier to these remedies that they have obtained. In other provinces, and this is something for the Supreme Court of Canada to sort out, in other provinces, the law is literally different. So there were Aboriginal title claims brought in the Ontario Superior Court and the Ontario Court of Appeal in the early 2000s by the Chippewa of the Sarnia for title claims over vast parts of the landmass of the city of Sarnia, including residential, commercial, and industrial land uses. That case failed for the First Nation on the basis that the Court of Appeal decided they had waited too long to bring their matter before the court. Yeah. And it wasn't the general Ontario law under their statute that says you have to bring a claim within 2 years of learning about it, or if you ought to have reasonably diligently learned about your claim and your loss and damage within 2 years, you have to bring it before the court. No, the Court of Appeal gave a much lengthier period. If memory serves, it was 60 years or perhaps even more than that. But that, in that case, did defeat the Aboriginal title claim. And the Indigenous people there, the Aamjiwnaang First Nation, Chippewa, the Sarnias, sought leave to appeal to the Supreme Court of Canada, and that leave was denied. The highest court in the land did not hear their appeal. So that is not the law in British Columbia. All of those arguments were put to this trial judge, and she decided that they were all unsuccessful defenses. So that gives everyone in the legal community some pause, and hence how the concerns about what happens to fee simple rights and interests in the event of Aboriginal title declaration. That's why it's not, in my humble view, fear-mongering to question that and be worried about it, because we already know from the case that has been decided so far in the Cowichan tribe litigation that there are real consequences to that. Canada used to own lands in this area of Lulu Island. It no longer does. The Cowichan do over these land parcels that Canada used to own. Canada no longer owns them, which is very interesting because I think that some of them are actually the subject of leaseholds, and I don't know where tenants are actually paying monies at this time to a landlord that no longer owns the land. But so there's that, but also the city of Richmond, municipally held lands created by the province under the provincial land title tenure system that Richmond ultimately owned, and it too has been had its land titles adjudged to be defective. And then we didn't get to it, but there's, of course, this YVR fuel project area
you did mention
for petroleum handling that is, among all of these parcels, not a defective title. So Canada still owns that one. And it has to, in order for, that's not the end of the story. It doesn't mean Canada keeps it.
Right.
It means Canada must now consult with the Cowichan people about, okay, how can we reconcile the use of this land to store and service the a pressing piece of important infrastructure for the Lower Mainland.
Got to keep the planes going.
Yes. How can we reconcile that with your Aboriginal title? And so that your listeners are clear, right. Aboriginal title was still declared over that petroleum handling area, that federal land parcel. It's just that, unlike the other land parcels in the 1,900 acres, that one isn't a defective title. So Canada, at this present moment, still owns it. The rest of Canada's titles, gone. And then, of course, in case any listeners came in at the end and didn't hear the beginning, we don't know what happens yet with the private landowners in the area.
Yeah, and that's kind of, as unsatisfying as an answer as it might be, it is, as we mentioned before, there's a lot to still happen. There's a lot of hurry up and wait. And it might be that we have you on again when there are some more substantial answers that will provide
For sure. That
we'd
might be more edifying,
we'd
too.
be pleased to do that.
Yeah.
More
I think
certainty.
we keep an eye on the 18, what happens
sure.
in the next 9 months here, under the 18 months.
Just the ongoing nature of this, right? I
Yeah.
think it lends itself to, continued scrutiny and certainly some continued input from experts like yourselves. So we really appreciate you guys taking the time, Josh, Wally. It's been a lot of information, and it's just great to get people who are on the ground, who know this stuff inside and out, and clearly you both do. So again, we really appreciate your time today. Thank you so much.
for inviting us.
Well, hope it's of use to your 15,000 members.
I
So,
think for sure there's going to be a nugget or two here that they're going to be able to take and run with. If not, really be able to get into it with some of their clients about what they need to consider. So
Very
thanks
good.
again. Really appreciate it. Realtors, thank you for listening. I'm Jesse Lalime, and we'll see you down the next Critical Path.